pause. I'm like, it's already going? I'm basically just okay, well, welcome to today's Lunch and Learn, medical IP for, well, intellectual property for life sciences. We have Allison Glasunow here from Perkins Coie, and she will be presenting today. This is live on Facebook and YouTube as well, so you can go back and watch this if you're a little late joining. Just going to hand it over.
Okay, thank you. Pleasure to be here, and looking forward to speaking with you all about what Perkins' perspective is on intellectual property for life science companies. And I apologize if you can see me step in and out of the screen, because I'm going to control the laptop from over this way. Just a quick introduction about Perkins, since we are new to this area. So Perkins Coie is a full-service law firm. We do have quite a large intellectual property group. We focus on everything from licensing and counseling to patent preparation and prosecution, copyrights, trademark, trade secrets, litigation. We have a strong practice in the post-grant proceedings as well as various enforcement programs. So with our intellectual property practice, we have more than 250 IP attorneys. Over 135 of us are registered to practice in front of the USPTO. More than 175 of us do have advanced science degrees, including master's and PhD level attorneys. We have a large group that focuses on computer software, electrical engineering, mechanical engineering, as well as the life sciences and medical device space. We have received several accolades over the years, most recently recognized as Law Firm of the Year by U.S. News for the best lawyers in the patent practice in 2018. Looking at our patent practice separately from our IP practice, we do have over 250 patent litigations that have been represented in the last 2 years, and 8,400 patent applications filed in the last 2 years. Just a quick example of some clients that we represent in the life sciences. We tend to cover everything from pharmaceuticals to DNA sequencing, as represented by these clients here. And in the medical device space, again, several other clients ranging from smaller med device clients up into the larger Medtronic-sized clients. So today I want to focus on just a general overview of IP, assuming that some of us have some familiarity, but maybe not in-depth familiarity. I'll dive a bit into the basics of what patents are, talk about some common myths, over a few different nuts and bolts when it comes to intellectual property for life sciences companies, talk about some patent strategies that you might find advantageous, maybe, and get into a little bit about the process for how companies go about acquiring a patent. We'll go over a few best practices, and then I'll talk just a little bit about some search tools and tips for patentability and why that might be important to look at for your company. So types of intellectual property, and this is not supposed to be animated. Just a quick example. So we have copyrights, which music is a good example. Publicity is a type of intellectual property. Trademarks, patents, of course, and then trade secrets. So IP rights, the various types of IP have different benefits to them. So trademarks, you can protect your brand. Copyrights, you protect your original works. Trade secrets can protect important technology that's difficult to reverse engineer. The key to trade secrets is that you have to keep it a secret. Patents, they can give you a defensive position and an offensive position. They're a source for generating revenue of licensing. They can play a key role in the valuation of your company. Publicity is a way to protect your image. So what is a patent? So patents are a property right that are granted by the government. It is personal property that can be bought, sold, licensed, or otherwise bequeathed. It is exclusive, so owners of patents have the right to prevent others from making, using, selling, or importing the claimed invention. One key thing with patents is they're territorial, so you must obtain a patent in every territory that you seek protection. So the United States, Europe, Japan, China, and every other country where you might seek protection. Timing of patents is important, so those are awarded to the first person to file an application for that patent. And in a way, they can give you a ticket to court if you feel like you need to enforce something against a potential infringer. So the bit of the quid pro quo with patents, patent owners get the right to exclude others from practicing their invention for a fixed length of time. This is about 20 years, and I say about because there are mechanisms that can extend or shorten the length of the patent. We can get into that if folks have specific questions there. But the bargain and the trade-off here is the public gets the full disclosure of the inventor's ideas about how to make and use the invention. So when your patent protection ends, it's freely open and available to the public to also practice your invention. So some common myths that are associated with patents. Some folks may think that the patent gives you the right to make, use, and sell my invention. That's actually not true. It's the right to exclude others from making, using, and selling the invention. It's not an affirmative right to practice your invention. This is because your invention may be illegal to sell. Or it could be that your patent covers some aspect of your invention that you don't necessarily have the freedom to practice because someone else may already have that right. So an example of this, for a medical perspective, is an intravascular stent. So let's say Gary invents and claims an intravascular stent that has a braided, elongated, expandable member. In this case, it's illustrated over a balloon. Ken discovers that by adding protrusions to the stent results in sustained positioning within the blood vessel. So Ken then decides to claim the braided, elongated, expandable member, but that it has these protrusions that extend radially from the intravascular stent. The problem here is that Gary's patent covers a broader stent than what Ken's patent covers. So Ken, despite having what he thinks is an invention, cannot make or sell this without infringing Gary's patent. Myth 2, I've never seen this product on the market, so it must be patentable. Well, whether or not a product is on the market, it's not the test that someone should apply. To qualify for patent prosecution, it not only has to be new, but it also has to be useful and non-obvious. So when you're considering whether or not this product that you have maybe not seen on the market or considering whether it's patentable, it's important to also look at the technical literature that's available, such as patent publications, the internet, or other references, and consider whether or not any of those references disclose or suggest what you believe is your invention. Another myth is that we don't copy anyone's product, so we don't infringe anyone's patents. Well, the trick here is that lots of inventions are patented, but not necessarily on the market. So whether or not you know about a patent or not, you still can be liable for infringing it. So before investing in a new product or any improvement that you may want to make to a product, it's really important to do some sort of a freedom to operate analysis and explore what's really known out there before you risk putting yourself in jeopardy. Myth 4, merely having a patent will stop others from copying my patented product. Well, if that were true, there wouldn't be patent litigation. It doesn't automatically stop anyone from doing anything. While patents must be enforced in the district court, and it is up to the patent owner to enforce them, some folks may be deterred, others may not. So if you do have a patent and it's something that you do want to protect, it is up to you to protect that asset. So just some basics on patents. Talk a bit about why they're important. So for many companies, patents are important because they help to capture the value on the investment that you've made and committed into the research and development of your product. They are a great way of taking what is typically an intangible concept and turning it into tangible property. Again, we mentioned earlier licensing revenue. This is also something that investors will look at and see what the asset ratio is. They give you the right to exclude others, as we talked about. And again, with the tangible property conversion and looking at it from an investor perspective, these really help to increase your valuation. IP in general does, but patents and trade secrets tend to have a bit more push with increasing a company's valuation. The other thing with patents is that they are market driven. So depending on the market that you're in, they may or may not be a most valuable asset for you. So you have to consider what it is that you're doing and what's the market doing. So who owns a patent? So they're fates, and in most other, or the inventors have an obligation to, may or may not have it in most cases. It's best practice to use a notary, but it's not something that's required. So one key takeaway with this, early of the invention, and attain all those signature documents as early as possible. Prevents the case of someone leaving and not being able to track them down. Trying to determine here is who conceived of the claimed invention. And the key applications include so the inventorship needs to be determined based on who contributes to conceiving of the invention. Even if only one person contributed a single small concept of that claims, there still must still be listed. It's not about how much you did, so much as you did something. Entire patents fail. To ensuring that your patents are as enforceable and valid as possible. So again, the patented invention is defined by the claims of the patent. They can be found at the end of the document. Here's a quick example off to the right. We'd like to say these are what are negotiated with the patent office. So when we file a patent application, we include sometimes drawings and figures, sometimes we include research data, especially if it's a clinical application, and then we'll include some other explanation in the body of the application. But the claims are what the patent office is examining and determining whether or not the invention captured by the claims is allowable. And the key with allowability is whether or not that the invention captured in those claims is distinguishable over what's already been known, which is the prior art. So is it something that's novel, and is it something that's not obvious? So critical dates. This comes up quite often for life sciences companies, especially those that are involved in some sort of university research or have another motivation to publish or publicly disclose their ongoing research activities. So the key here is filing patent applications before these critical dates. It used to be in the United States that it was the first to invent. It's now the first to file. So filing your patent application as soon as possible is key. You must do this within the US. We prefer, and our standard practice is to encourage folks to do this once they know that a public disclosure is going to happen, and ensuring that this occurs before that. In the United States, you have a 1-year grace period where you can say, whoops, my mistake, I shouldn't have said it before I filed it, I have a year to go back. If you're interested in protection in other jurisdictions, that grace period does not apply. So your public disclosure will be held against you and can preclude you from getting a patent on that technology in countries or in areas such as Europe and many Asian jurisdictions, including Japan and China. And unfortunately, this is something that can't be fixed. So I mentioned lab notebooks because they are one of the greatest resources for us as patent attorneys and for inventors and life science companies to look and track timelines as far as what was done, when it was done, and who did it. So for those of us that are grad students or have been grad students, the dreaded lab notebooks are still critical. So these are things that we spend quite a lot of time poring over. We look at them as far as what's the content and the subject matter of the application. We look at them and just help decide whether or not it's time to file a patent application or whether more time is necessary. And they are a big, big resource for us improving inventorship and looking at who should be assigned and listed as an inventor for certain situations. In general, with lab notebooks, as best as possible, we like to encourage everyone to focus on clarity and to know your audience. So if you're preparing materials in your laboratory notebooks for looking at patent applications, thinking about who the audience is that's reading these. So whether or not it's your colleagues, patent examiners, and in many cases, judges. To the extent possible, sign and date each page and have it witnessed, which helps quite a lot, and avoid modifying any entries. Electronic lab notebooks are becoming more of the gold standard, which is great. They are admissible as evidence, though, in the district courts, so long as they comply with certain federal rules of evidence. So to the extent possible, if you are using electronic notebooks, ensuring that you're using verification software and that any industry standards that are required by the FDA or maybe any other regulatory organizations that you're working with, that those are things that you're keeping in mind and complying with. So turning to patent strategy, with patent strategy, I'm going to show all of these here. So the invention when it makes sense to commercialize, or how it fits into your overall business strategy, whether it's an asset and what the criticality of that asset is. So oftentimes we're encouraging clients to seek patent protection. This is what forms the backbone of your company, but then also focusing on certain for your service from your competitors or people that you foresee becoming a competitor. And then also narrowly focusing more on the key aspects of your process for using those products and services. To clear these new products with various types of searches. So the question we're answering here is whether or not there is that product that they may or may not be trying to commercialize. Too. So I mentioned it more so with respect to academic institutions because that's often where we see the pressure to publish and the pressure to present new data as it's coming out. But it's also important with commercialization. So one of the issues that we often see is someone making an offer to sell a product to somebody, and that counts as a disclosure, even if you haven't made that offer necessarily public. So there's a lot of situations that can arise as disclosures, so keeping timing in mind when we're considering strategy as well. Let's talk a little bit about, so we're preparing patent applications, the first thing we're looking for is how are we going to describe the invention, and we're looking at the lab notebook or any other records that are preferably dated and witnessed. And then we're going to evaluate the invention. So we're going to look at a few different considerations here. We're going to look at whether or not there's sufficient payback to warrant patenting, because the other sources of IP can include trade secrets. So is this something that can be reverse engineered? Is there more value by keeping it a secret, like the recipe for Coke, or what used to be secret, the KFC coding recipe? And then because of some of the strategic considerations, you might consider filing a patent application or otherwise publishing your technology to prevent someone else from patenting it. Maybe it's not something that's patentable for you, but it is important to keep you having the right to do that so you can defensively publish your work, which would then create prior art for someone coming after you is now going to have the challenge to differentiate over you. If none of those considerations outweigh the benefits of filing a patent application, we then look to prepare and file that patent application. One key thing here with the patent application itself, so in addition to having the claims, we have the description of the description and the specification as well as the figures. Once that is filed, you cannot substantively change that. We can amend the claims and add new claims, but they all have to be based on the disclosure originally surrounding it. So if you have a new figure or a new aspect to it that you want to include, those can't be added after you've initially filed that application. They would have to warrant a second application. So a typical process for what many of our life sciences companies look at, we often first file a provisional application. This is not examined. It's relatively inexpensive on the filing fees, and it gives you 1 year. So it starts the 1 year clock, puts your stake in the ground, and says, as of this date, This is when I invented A. So within those 12 months, you consider cooperation treaty, or whether or not you want to file into direct and individual both. It's about, I think, almost 170 of them now. There's some key countries. Oftentimes our clients will file directly into the United States as well, so we'll have two cases. Everything highlighted in blue here is a PCT country. I have clients filing in Argentina, Iraq, and Taiwan. So about 6 months after you file this examined application, this PCT or the direct individual examination process, you need to only file in the United States. Most countries require that you disclose every. After about 12 months, if you've filed a PCT application, this is a huge cost-saving measure instead of filing direct into all those individual countries for many companies, because you're not necessarily paying all your translation fees and all your direct filing fees up front. Depending on your technology and the complexity, about 1 to 5 years later, you might find yourself with a patent. And that patent can be in the United States or any of these national countries. And then we start filing what are called continuations or divisionals. So using that initial application, that PCT and or direct or individual country application that had published, you can file subsequent patent applications claiming priority to that using the same figures and disclosure if there's a different set of claims that you want to go after. So say that application, you described inventions A, B, C, D, and E. You got claims to invention A. We can now go back to that same priority date and look at getting claims to invention B, C, D, E, all the way along. And then each of these patents will have the term based on the initial application filing date. So anywhere from about 13 and a half to 17 and a half years later, your patent will expire. Some patents may be eligible for patent term adjustment or extensions. So there are ways to get more than 20 years, and this is patent term adjustment as if there's been any delays during prosecution in the United States that may have occurred by you or by the patent office. For example, if it takes 2 years to get your first communication from them, for example, you can extend that term. Patent term extension is one that is awarded on regulatory approval. So if you have a drug or a device that's sitting in front of the FDA and it takes several years to get your approvals, you can get up to about 5 years in patent term extension. So you may have a patent that ends up being 25 years in length in the US versus what's normally 20 years. So these are the various stages that we refer to them as, kind of the initial search drafting stage, this prosecution phase, which is when we're negotiating with the various patent offices for what claims, and then overall maintenance. And maintenance is important in the sense that you're considering, are there any other continuations you want to file to go after invention B, C, D, or E while that first application has just been allowed? And also fees. You pay ongoing fees to the U.S. Patent Office to keep your patent in force, and you also pay them to the various other jurisdictions that you may have a patent in. So patent marking. This comes up on occasion. It's critical to put others on notice that you have a patent pending or an issued patent on your product. And this helps if you have an infringer and you end up litigating and needing to go back and sue them for damages. Depending on the technology, damages can be tens, hundreds of thousands, millions, multi-millions of dollars. So marking your patent or your product as subject to a patent pending is important. Or that it's actually covered by your issued patent number. And you can also include the internet address depending on the technology, if it will fit on your product. Sometimes it's too small and doesn't. And you can also put on the packaging that it's sold in. So looking at the patentability search options, this is something that we perform for our clients, but it's something that you can do a bit on your own if you're not ready to engage with a full search. And this is one of the techniques you can use to determine whether or not your invention is new, whether or not someone else has already a patent on it, and you should consider those results carefully. So the various considerations that you may have if you're thinking about a product and whether or not it makes sense to do one of these searches is first determining if you want a patent on your product, what's the likelihood that you're going to be able to get one. It's not inexpensive, depending on the type of firm that you're engaging with, depending on your technology, the level of how complicated it is, and how many jurisdictions you want to go into. It is not necessarily inexpensive. And so if you haven't yet done a search, you might want to consider doing that to avoid wasting quite a bit of time and occasion quite a bit of money. The additional thing this helps with is to facilitate preparation of the application. So if we know ahead of time maybe how similar technologies are out there, we can already craft the application with the intention of distinguishing you from what's already being done. And this can provide a lot of advantages during prosecution. It can make the process much faster, much less expensive overall. It also helps you obtain commercial information. And then if you're unsure about how the patent may give you commercial advantages, it can also give you information about or someone else that's in the similar space to you that you maybe didn't know about before. Again, it helps you understand what your competitors are doing and the art that they've created. And in looking at if any are uncovered that are quite similar, the whole public, the whole prosecution history and everything that they went through with the patent offices is public. And so you can go in and look and see how difficult was it for them to get this patent issued? What hurdles did they have to overcome? Are these ones that I'm going to face? And if so, what are we going to do about that? Is there anything we can do ahead of time now to anticipate those and have a much quicker or less expensive way to overcome them? In addition, it may give you some ideas to improve the functionality or the operability of your invention. You can clarify what it is that's your point of novelty. What's your secret sauce on your invention? What's the big value add that you have over what's been done before, if something similar has been done before? Again, it really, really, really helps to know if there's any valid patents that exist on a product similar to what you're thinking, and can help shelter you from potentially infringing those. So I'll go over just finally some best practices and kind of key takeaways. We tend to look at some of these patent perspectives and IP perspective for that matter for what investors want to see. Looking at working with, they have different considerations. They may want to see that you have at least established that you have technology that's protectable or that you're really investing in and you're standing behind. It's not just an idea that you've whiteboarded out. The product itself fits into your overall commercial goals. With some of the more venture capital type investments, if you're seeking larger sums, they are looking for a bit more than just an initial application or an application that's undergoing. So they want to see that you have a portfolio or at least a plan to have a portfolio of patent filings, something underway where when we talked about the timeline that you had, patent 1, 2, 3, 4 as continuations, they want to see that you've got this large kind of kitchen sink application that's covering all the various iterations of what you're doing, and that it's one that you can go back and mine for future. Early date keeps everyone, once you have that flag in the ground in that early date, let's say it's 2010 and you invented an antibody that now in 2012 everyone is jumping on. Well, if you can keep going back to that 2010 date, you're still novel over everything else, even though it's being done before today. They are concerned with your IP ownership. They want to make sure that all the inventorship issues that we mentioned are not a consideration, that all the assignments are properly done, that any sort of agreements with a university, which comes up a lot for life sciences companies or any research institutions, are complying with their IP policies. They're also very concerned about the searches that we just talked about. So they want to know that you're aware of what your landscape looks like and that you've considered what the competitors are doing and that you've looked around to make sure that, let's say you don't have a patent on your technology, or if you do have a patent on it and it's later proven invalid, do you have the freedom to operate? Can you still sell your product? Or are there other patents out there that are so close to that would cover what you're doing that now you can't use your product either? And so that really kind of boils down to whether or not you have the ability to practice your own technology that are pending. With respect to medical device startups, the IPO of the average medical device company without IP, you're looking at a $200 million difference between no IP and IP. This is largely driven by patents, next up by trade secrets, and then trademarks and copyrights. With acquisitions, there's a lot of the M&A practice that we have. We see very similar returns on a company's IP investment. So it's really key, at least in our perspective, and from what we've been seeing, to develop the following day of developing that strategy, starting to refine it and whiteboard it and work with it and see how it fits into your overall company. So in an ideal world, it's key to preserve your geographic patent scope. So for life sciences companies, you may be not just in the US. We see them doing them in Australia. We see them in China. We see them in Singapore, Indonesia, Taiwan. Or other sorts of research or manufacturing or production is important. You file your application, ensuring that you have a PCT application on file that keeps those doors open. Have all of your inventors or people that you think are inventors that it's better to over-assume invention and have these assignments executed rather than to under-assume. There's unfortunate situations where inventors become hostile and don't want to assign something. Or that you can't office when they're examining your patent application and your claims. They're looking at the patent on this invention anyway if you would be infringing. That is not what they're looking at. Or two different analyses. After detail. We've talked a bit about filing the publish or commercialize. And publish has a very broad definition from the Patent Office's perspective, both the US Patent Office and foreign patent offices. So if I was talking about an invention here, this is a publication. This would count. If I'm talking about it in a under NDA in a confidential situation with the understanding that it's in that, someone at the bus stop or down the street, that can count. Whether they find it or not, it's a different story, but you do have a duty to disclose things like that to the Patent Office. So it's important to keep your records and keep track of what you're doing. Breaching your duty to disclose to the Patent Office can also invalidate your patent. When you're thinking about your invention or anything that you may want to capture with your intellectual property, thinking about it in ways that you could use it differently. And this is ways that we refer to it as embodiments in the specification. So today you may envision it as one iteration. How would you think about it tomorrow? How would you think about it in 5 years, and in 10 years, and in 15 years? And this is important because your patent lasts for 20 years. So trying to capture down the road how you see it, could possibly foresee it evolving within reason, is important to capture in your application to give you the broadest protection possible. We didn't talk a lot about design patents. These come into play, the Apple-Samsung case, that's huge decision, was all in the design of the product. So you can get a patent on how your product kind of just looks, the overall user experience of it. We see this a lot with a UI setup. They are relatively simple, relatively inexpensive. They can provide quite a lot of value, and in the last 10 years, I would say they've definitely been showing their value more so than in the years preceding that. Again, developing a patent portfolio strategy, something that you don't necessarily need to execute on tomorrow, but something that continually evolves and moves and changes as your company and your invention grows. And then the last thing is just the importance of trade secrets. Trade secrets, I think is Zillow truly a case? I forget what just shy, I think, of 300 million on a trade secret misappropriation case. So the amount of financial investment that can be put behind trade secrets, and if you think about the myths of, the Coke recipe is behind a locked door with guards, and then this, and this. I mean, protecting that is what keeps them able to keep operating. So, whether or not you have something that's a trade secret, and keeping it as a secret could provide a heck of a lot more value than a copyright, a trademark, or the key with that is making sure it stays a secret, and that can be very difficult to do. And there's lots of different ways to implement that and different security measures that have to get put into place. Trade secrets, on those, so trade secrets and copyrights, unlike patents and trademarks, you don't need to file an application to protect them. They just exist. So this presentation is copyrighted for 90 years after I die. And any written work or any embodiment that you put together automatically has a copyright associated with it. It's helpful to protect it and to file with it for registrations and whatnot, but it's not necessary. Trade secrets, there's no institution in which you file to protect those. Those are just something that you have as a company asset. So long as it's a secret, it's protected. So one of the last key slides I'd like to show you, Perkins Coie has a resource that we make available to anyone, but it's more directed towards startups. We call it our Percolator. So this is a snapshot of our website that has all that information. It gives you some information. There's also investing, different events that we may put on, or some of our partners may put on. It also includes some different tips and videos. So we have clips in here from various partners talking about different things that come up during their practice that may be interesting to startups. It's a complete, and that's all that I have prepared. I have quite a few extra things we can dive into. If folks have specific questions, I can see if I have slides about those, but otherwise I'll wrap it up and take any questions that might be outstanding.